Good evening. Thank you all for turning out tonight on what is a beautiful evening. The sun is setting, and thank goodness for these blinds to keep us out of the rays. Thanks for being here for what really does promise to be an engaging and thoughtful discussion of the tensions between religious liberty concerns and LGBTQ interests in law and politics in the United States. My name is Daniel Bennett. I am an associate professor of political science at John Brown University, and I'm also the assistant director for the Center for Faith and Flourishing. A little bit about CFF. We exist to defend and promote JBU's historic mission of educating for head, heart, and hand. By faith, we mean the Christian faith. By flourishing, we mean human flourishing. Seeking human flourishing makes us more, not less, concerned for the good of society as a whole, because people can flourish only in broader social networks that allow them to discover and to express who they are and what they are meant to do with their lives. Likewise, principled commitment to our Christian beliefs makes us more and not less open-minded to opposing points of view, trusting in the idea and the fact that all truth is ultimately God's truth. In all, the center strives to articulate what it means for humans to flourish and to help people flourish both individually and together. Tonight we're excited and delighted to welcome to campus Greg Baylor, Senior Counsel with Alliance Defending Freedom and Director of ADF's Center for Religious Schools.
Yes.
Is that correct? Great. It's been great to have Greg with us on campus throughout the day, meeting different people, having lunch with students, entertaining fun questions and discussions in my political philosophy class this afternoon. Since joining ADF in 2009, Greg is focused on defending and advancing the religious freedom of faith-based educational institutions through advice, education, legislative and public advocacy, and representation in disputes. He has testified about religious liberty issues before congressional committees on multiple occasions. Greg regularly comments on religious liberty and higher education issues in television, radio, and print media, including in the New York Times, Christianity Today, National Public Radio, and network and cable news programs. Additionally, he served on the board of directors for the Museum of the Bible and the International Alliance for Christian Education, and has also served on the board for the Council for Christian Colleges and Universities, of which JBU is a member institution. Greg earned his law degree in 1990, I almost gave you another decade.
I'll take it.
That's right. 1990, from Duke University School of Law, where he graduated with high honors and served on the editorial board of the Duke Law Journal. He received his bachelor's degree in honors English in 1987 from Dartmouth College, which is the alma mater of the center's director, Jay Bruce. I'm sure he'd be very happy to know about that. Following graduation from law school, Greg served as a law clerk to the Honorable Jerry Smith on the U.S. Court of Appeals for the Fifth Circuit. He practiced labor and employment law at two large firms for 3 years before joining the staff of the Christian Legal Society's Center for Law and Religious Freedom, where he served for 15 years prior to joining ADF. He lives in Northern Virginia with his wife, who is a medical doctor and also learned on the FDA, which is super interesting, and two college-age daughters. Please join me in welcoming Greg Baylor to John Brown University.
Thank you, Dan. Appreciate it. Thank you, Professor Bennett, for that introduction, and thanks for coming out tonight. It is a beautiful night. It might be nicer to be outside, but we'll try to make this enjoyable. I'm delighted to have been invited to campus. I've really enjoyed my time here. I've not been in this part of Arkansas before. It's beautiful, and I hope to have an opportunity to come back. ADF, how many have heard of Alliance Defending Freedom, the organization that I work for? It's a pretty good percentage. Oh, by the way, my FDA. So my brilliant daughter, she's now 20, I think she was about 6, when she realized that dad works for ADF and mom works for FGA. It's just like the mirror. I'm like, what a brilliant child, right? Never thought of that. Anyway, yeah, we're an alliance building legal ministry, and our mission is to advocate for the right of everyone to freely live out their faith. As Professor Bennett mentioned, I've been at ADF for about 12 years now, and I have a couple of hats that I wear that I think qualify me to talk about this subject tonight. My biggest niche is serving the religious liberty needs of faith-based educational institutions. Most of them are Christian, but not all of them. I've worked with schools from other faith traditions as well. And that these days consists primarily of just providing legal advice when they have situations that arise. I used to do a lot more litigation, representing colleges and universities in disputes in court. It's hard to do that and my other job, which is legislative advocacy at the same time. So I'm in court less than I used to be. My legislative advocacy work for the last few years focused on things going on at the federal level, whether it's Congress or the administrative agencies. Just this year, I foolishly volunteered to help out with some state legislative activity and learned that the volume of legislation that states propose is really overwhelming. I started in this area of religious liberty about 27 years ago. I wish I had that decade back, but about 27 years ago. And when I started in 1994, the big issue was equal access. The big issue was equal access. And what do I mean by equal access? Well, there was an idea that was commonplace in the law, really from, you could go back to the 40s, all the way through to the 70s and the 80s and even into the 90s. And the idea was that the Establishment Clause and state analogs to it, separation of church and state, right? We've all heard that phrase. There was an understanding that it meant something particular, something that I think was wrong. And the idea that was prevalent in the legal world was that if government is handing out benefits, it can't hand out benefits to religion. It must discriminate against religion. What am I talking about more concretely? Well, when I first started, one of the big issues was access to meeting space. You know, schools would have student clubs that would meet after school to do whatever they're going to do. And then there would be like a Bible club that would show up and say, hey, we want the same access to this meeting space that the secular groups are getting. And the schools frequently would say, nope, we can't do it. We'd love to let you do it, but if we do that, we're going to get sued by the ACLU for violating the Establishment Clause or church-state separation. And that was what I focused a lot of my time on, is representing student groups and good news clubs. Who's heard of good news clubs? Child Evangelism Fellowship had good news clubs, and a lot of them were being denied the same access to meeting space that secular groups were getting. There was a related debate about access to money. One of the reasons why we have no established church in the United States is because the founders said, you know what, you shouldn't have to pay the salary of a minister whose views you disagree with, which makes sense, and I agree with that. However, that notion, that historical experience that underlay the Establishment Clause was overinterpreted to mean the government can never give money to religion. So suppose you have a hurricane or a tornado that runs through a town, and the federal government, FEMA, comes in and says, we're going to spend some money here to rebuild some of these buildings. We're going to rebuild the grocery store, and we're going to rebuild the factory, we're going to rebuild the school, and then they get to the church or the Christian school. They would say, no, we can't rebuild that because you're a church. We can't spend money on religion. Now, it's one thing to say, we're going to only rebuild the church. That would clearly be wrong, right? We're going to prefer this church. And even worse, we're going to rebuild this Presbyterian church and not this Catholic one or something like that. But the idea going around was like religious entities and individuals can't participate equally in government benefit programs. So all of the cases that I was doing when I first started in 1994 had to do with this issue, this sort of conflict between access, free speech, free exercise of religion on one hand, and this kind of distorted idea of church-state separation. Well, the good news is that that idea is largely, not entirely gone, but it's largely been diminished, at least. The courts are interpreting the federal Constitution much differently these days, and now they allow for equality. Now, you can't favor religion, but you can't discriminate against it either. Now, why am I saying all this? Well, this is not The victories were a great thing, but they meant that something else was coming. And when I was still fairly new at Christian Legal Society, we recruited summer interns at law schools. And back then there was no internet, so you would actually send like a firm resume and they'd stick it in a manila folder. And the students would come and they'd flip through the folders and, oh, I'd like to try working at that firm or the other firm. And we approached a number of law schools and said, we'd like to put our little firm resume in your little folder system. And they looked at it and they said, this is okay. We have one problem though. You require your interns to be believers. Mind you, this is the Christian Legal Society. We had a distinctly Christian mission that had to do with evangelism and discipleship, integrating faith and law. So it made sense that we would want our employees and interns to be Christians. But the law school said, you know what that is? That's discrimination. That's discrimination against people who don't share your faith. They had a second problem. CLS, like a lot of theologically orthodox Christian organizations, has conduct standards. And those conduct standards reflect Christian beliefs about various issues, including the sexuality issue. They don't care that we're against murder and against theft and against cheating and stealing. They do care, though, about our views on sexuality issues. So about the morality of homosexual behavior, the definition of marriage, and later with the gender identity issue, the distinction between the sexes. So we had conduct standards for our employees and for our interns. So these law schools would look at this, firm resume and say, I'm sorry, you're violating our non-discrimination policy. So it was early in my career in 1995 when I first confronted an issue that would actually in some ways come to define my time trying to defend religious liberty, but first at CLS and later at ADF. By the way, the two schools that we first approached, one of them was Harvard and one was Yale. We started high. And they came out differently. Yale would not change its mind. We made the observation that most laws that forbid discrimination on the basis of religion, sexual orientation, and things like that had exemptions for religious employers. A church can say, we'd like our pastor to be a Christian. A mosque could say, we'd like our imam to be Muslim, and so forth and so on. And most of the then existing laws regarding sexual orientation discrimination had exemptions for religious organizations. So it wasn't a matter of us violating the law, it was a matter of us maintaining our character, right, through the choice of people who make up the organization. Well, that fell on deaf ears at Yale. We got a better hearing at Harvard Law School. There were two professors on opposite sides of the ideological and political spectrum, a woman named Marianne Glendon, who's a faithful Catholic and a conservative, and Alan Dershowitz, who you may know, he's kind of famous. He's more a liberal end of the spectrum, and they came together and said, no, this is not like some big law firm discriminating on the basis of religion or sexual orientation. There's a reason why they're doing this, and it's morally different, right? So we were able to get put on our little folder in Harvard, but not at Yale, and so it goes. Okay, so our topic tonight is sort of the tension between religious liberty and LGBT interests. I think it's important to define these things that we're saying that are in conflict before we just jump in and describe some of these conflicts. Religious liberty, technically it's not a conflict between LGBT interests and religious liberty. It's more a conflict between a certain kind of religious exercise, right? A certain kind of religious exercise that's predicated and rooted in a certain set of religious beliefs. And those beliefs are, as I hinted at earlier, are about sexuality issues, which are obviously controversial. They were controversial in 1995. They're more controversial today. Orthodox Christians believe, as you know, that marriage is between one man and one woman. We believe also that in terms of sexual morality, sexual relations between two people of the same sex is sinful. And we also hold that God created the male and female, that there is a distinction, a meaningful distinction between men and women, and that biological factors and considerations are sort of more important and superior to sort of subjective self-identification. These are the religious beliefs that are problematic, and cause the tension. It's really not the beliefs themselves, it's really the actions that are based on those beliefs. And what kind of actions create the tension? Well, as you probably discern from my story about Harvard and Yale, it really has to do with the formation of your community, choosing who your people are, right? Any organization really can only maintain its character, not by having things written down on pieces of paper, but having people who work for the organization, who lead the organization, that believe the things on that piece of paper. So it's the decisions that churches make, that Christian colleges like John Brown University make when they hire staff and faculty. They're looking for more in a faculty member than just experience, education, scholarship. They're also looking for someone who can help integrate Christian faith into the teaching and someone to be part of a Christian community. Now, some educational institutions, of course, extend that to the student body and require all of their applicants or admitted applicants to be believers. That's not John Brown University. But even then, a lot of schools will say, look, we don't require you to have any certain beliefs, but we do have conduct standards for you that are rooted in our religious beliefs. So it's really these conduct standards, these requirements, these non-negotiables really, that many religious organizations have that are the cause of the tension, okay? And what LGBTQ interests am I talking about? Well, there are many, and there are many that I'm not talking about. Let me list some of those. Not that long ago, probably in the 1980s, one of the objectives of the LGBTQ advocacy organization was to invalidate or repeal laws forbidding sodomy. And they unsuccessfully attempted to do that in the Supreme Court in 1986, but did so successfully about 15, 20 years later in a case called Lawrence versus Texas. Another item on their to-do list was access to the military. Obviously, marriage, gaining access to marriage. Marriage is recognized by the state. And then access to the foster and adoption system, being able to serve as a foster parent or an adopted couple, because many states had laws that forbid that for individual homosexuals or for gay couples. But I'm not talking about any of those as the causes of the tension that we're going to focus on tonight between LGBTQ interests and religious liberty. It really is non-discrimination rules. Just like Harvard and Yale said, hey, CLS, you're discriminating. There are a burgeoning number of non-discrimination rules that now include sexual orientation and gender identity. And it's those rules that really are the source of most of the tension. Is everybody with me? Does this all make sense? Okay, good. Glad to hear it. So non-discrimination rules are in tension with the desire of Christian organizations to form their communities by choosing people who not only agree with them on paper, check the boxes on the statement of faith, but also are willing to live their lives in a manner that's consistent with Christian conviction. So, non-discrimination rules. We're going to get into the weeds a little bit here, I'm sorry, but what lawyers like to do, they like to take a big jumble of stuff and divide it up into categories. And there are lots and lots of non-discrimination rules out there, and I thought it might be helpful to divide them up into little boxes, which if they're neat and organized, it makes me happy, because I'm an OC person. So anyway, non-discrimination rules. First way of thinking about them, who's writing them? What is the source of the rule? There's essentially two categories: government, not government. Government is also further divided down. You have the federal government, you have the state government, and the local government. I mean, the great thing about America's power is divided. The terrible thing about America is you have three sets of government that you have to worry about doing something you don't like. So non-discrimination rules can be enacted by governmental actors, state, federal, and local, and they can be enacted by non-governmental actors. So when the NCAA tells a school you have to allow a male who identifies as female to play on the women's sports team, because if you don't do so, it's going to be discrimination, that's a non-governmental actor telling someone they have to comply with a non-discrimination rule. An accrediting body, JBU is accredited, it has regional accreditation. You might have some program-specific accreditations. Accreditors generally have non-discrimination rules. And there's a lot of concern about what might be on the horizon there, with accreditors telling schools like JBU, if you have standards of sexuality standards that we would characterize as discrimination, that we're going to strip you of your accreditation. So one way of thinking about non-discrimination rules, sources: government, different kinds of government, non-government. What contexts? That's another way of thinking about this. Where is discrimination forbidden? Well, the biggest one is employment, right? It's illegal to discriminate against people in the employment setting. You can't not hire someone because of the color of their skin, or because of their sex, or their national origin, their religion. Other contexts include, businesses, business establishments, places of public accommodation in the language of many of the laws. So if you run a grocery store, you can't say, wait a minute, you're Muslim, you can't shop here, or something like that. Or if you're, the historical motivation for a lot of these was African Americans traveling in the South and being turned away from restaurants and hotels. So those are places of public accommodation. What else? Housing. There was a problem with the treatment of African Americans in the housing context. I suspect that there still is in some places. And so that's another context in which we see governments adopting non-discrimination rules. Education itself as a special category, both public and private, are subject to certain non-discrimination rules. And then accreditation, as I mentioned before, is a context. And tax-exempt status is the government cares, right? When they're giving out tax-exempt status to nonprofits, whether they're discriminatory or not. Okay, so we've talked about sources, we've talked about context, now we'll talk about types. There are two types of non-discrimination rules. The first one is, it's like sort of a condition on a benefit. The government says we have this program and we're gonna, like student aid, that's a great example. We have a student aid program, we're gonna give the poorest people grants, we're gonna give slightly less poor people loans, and then you go and take it to your school and you help pay for your tuition, right? The government also says, oh, by the way, the school that gets that money, they can't discriminate. So that type is a condition on a benefit, right? The school can theoretically avoid this rule by saying, it's not going to take the money, right? They have a choice. Now, it's in some cases not a realistic choice. At this day and age, most Christian liberal arts institutions would not be able to flourish or even survive if their students were unable to direct federal student aid and state student aid to them. But at least in theory, you have a choice. So that's type one, a condition, right? A condition, a deal. He who pays the piper calls the tune is the cliche that's used for this. The other type is, here's the rule and it applies to you because you're here. You can't get away from it unless you move away. And the here can be the United States, or it can be the state of Arkansas, or it can be, a county, Fairfax County, or the city of Fayetteville, or something like that. So those are the two types, and this will come up as we talk about specific examples of conflict and tension between religious liberty and LGBTQ interests. The last way of dividing up non-discrimination rules is, who do they protect, right? What are the protected classifications? And there is no one answer to this question. Different laws have different lists of protected characteristics. Even within the most famous non-discrimination law is the 1964 Civil Rights Act, and it addresses public accommodations, and it addresses employment, and it addresses recipients of government money. A couple of other things. There's a separate law, the Fair Housing Act, that governs housing. The list of protected characteristics in each one of those is different. Now, you see race in every single one of them. You always see race, and that makes sense given our history. You often, but not always, see sex. You often, but not always, see national origin. You see religion frequently. When you get down into the states, you start seeing more, I wouldn't say marginal things, but additional things like your political affiliation or your appearance. There's, there are states say, like, you discriminate against someone because they're not tall or because they weigh too much or something like that. That's illegal in some places. So you have different lists of protected classifications. And one of the things that we'll see is you've had rules that never had sexual orientation or gender identity in them come to have it. And then you have the conflict, right? That's where we're headed with this. So, short primer on non-discrimination rules over. Now we can talk about, oh no, it's not over. I got one more point. Exemptions. So this is interesting. I don't know of any non-discrimination rule that has an exemption for race discrimination. I don't know. There may be one, but I can't think of one. And that kind of makes sense, right? Can you imagine a circumstance in which race discrimination would be justified? It's hard to think of one, right? But what about religion? Is it really wrong for the synagogue to say we want our rabbi to be Jewish? Well, I don't think so. I think that's different. I think that's morally different, and I think the law should treat it differently. And the law does. Almost across the board, the law will say, look, if this was Google doing this, saying we want this employee to be Jewish or not Jewish or whatever, that'd be illegal and it's wrong. But when it's a religious organization, they have latitude on that issue, right? Makes sense. So yes, religion is a protected class, but there's customarily religious exemptions for religious employers and individuals. Even sex is not treated the same way as race. So the most famous ban on sex discrimination in the United States is Title IX, right? And we think of athletics, but yes, it's about athletics, but it's not just about athletics. It's really about everything. What is Title IX? Well, it's a condition on a benefit. Remember we talked about that? JBU is subject to Title IX because it gets federal student aid. So it's a recipient of government money, and if you want to accept that money, you have to comply with Title IX. What does Title IX say? It says no sex discrimination. It doesn't say equality in sports. That's an application of it. It just says no sex discrimination. But it recognizes that there are legitimate circumstances in which it is legitimate to treat the sexes differently or at least separate them. So Title IX acknowledges that you can have a women's team and a men's team. Title IX recognizes that you can have a women's dorm and a men's dorm. Now, they can't be of unequal quality, but you can separate. You can't do that with race, right? You can't, but you can do it with sex. So sex is in a lot of these non-discrimination rules, but it's not categorical. It's not categorical in the way that race is. Other exemptions, housing discrimination. There's a gut sense that a gigantic apartment complex is different than someone renting a room in their house or renting the little apartment over their garage. And so a lot of laws that forbid housing discrimination have an exception, not religious one, but just for small landlords. You have a unit that's in your house or next to your house. You're just free to do what you want. We're not going to mess with that. In the employment context, most employment statutes will say you can discriminate on the basis of a protected classification if that classification, whether it be sex or religion, whatever, is a bona fide occupational qualification. So they contemplate, right, that there are some circumstances in which it's legitimate. Some of the cases I've seen have had to do with, like, who's going to pat you down at TSA, or like labor and delivery nurses, situations where it's appropriate to have one sex or the other performing that task. By the way, race can't be a bona fide occupational qualification. It's treated different. And then, of course, religious exemptions. As I've mentioned before, most statutes that forbid religious discrimination in employment say religious employers can take religion into account. Okay, so now the primer's done on non-discrimination rules. Wow, you're living my life now, okay. When do the story of the tension is really the rise of sexual orientation and later gender identity non-discrimination rules. There are two municipalities that kind of fight about who was first in adopting a sexual orientation non-discrimination rule, whether it applied to employment, public accommodations, housing. And I think the winner is East Lansing, Michigan, the home of Michigan State University. The other contestant is, unsurprisingly, San Francisco. But they were both early adopters, right, of non-discrimination rules. This was in around 1977. So you're about 13 years after the federal government made its big move on this issue and adopted the Civil Rights Act of 1964. Then you started, well, the first federal effort, it wasn't a very serious one. There was a congresswoman from New York City who I remember because I grew up outside New York City named Bella Abzug. And if you were of my vintage, you would remember her because she always had a very interesting hat on. That was her trademark. Very liberal from New York City. And she was the first one to introduce a bill in Congress that would add sexual orientation as a protected class. And I think it was just to Title VII, the civil rights, the employment piece of the Civil Rights Act. So, you had a couple of municipalities, you had kind of a feudal effort in Congress, but really started happening is the bluest of the blue states started amending their existing non-discrimination statutes to include sexual orientation. So California, New York, New Jersey, Maryland, Massachusetts, Oregon, Washington, they have the oldest non-discrimination statutes. And there's an interesting feature of all of them. They all have very robust religious exemptions. They have very robust religious exemptions. And it's kind of ironic, right? Because you would think the most liberal states would have the smallest exemptions. But it's because of the time this was happening. If you're pushing for a gay rights law in 1993, you have to make a concession, right? You have to say, look, this is not going to apply to churches and religious schools and all of the rest. Otherwise, it's got no chance of passage. So I think it was just a smart, tactical decision, right, to exempt religious organizations. Also, the idea that religious organizations should have freedom, more freedom maybe than other employers, was still okay to say. It was still okay to say that in an acceptable company. The idea was, more established than it is now. So you have them adopting these rules that in theory create detention, but don't because they have robust religious exemptions. So some of the first conflicts that we saw didn't really involve religion per se. The first time the Supreme Court dealt with a conflict between a gay rights law and some fundamental First Amendment right was a case involving the St. Patrick's Day parade, of all things. Massachusetts had adopted a law that forbid discrimination in places of public accommodation. It's a rule that applies because you're in this Commonwealth of Massachusetts, right? It's not a condition on a benefit. The interesting thing they did, though, was they said the parade itself, which was run privately, by the way, it was a private organization operated this parade, kind of a group of Irish folks in Boston held the parade every year. And the state said, your parade is a public accommodation, which was kind of weird because most people thought it was like hotels and restaurants and grocery stores and all of that. So they had a very expansive understanding of what's a place of public accommodation. Why am I saying all this? Well, what happened was a gay rights organization said, we want to march in your parade. And the pretty conservative Irish Catholic guys who were running this parade said, you know what? We don't think that fits with our message. This is a pro-family kind of apple pie Americana kind of deal, and we just don't think that fits. And they said no, so they couldn't march with them. So, being good Americans, the gay rights group got a lawyer and filed a lawsuit. And they said, their argument was, the parade's a public accommodation, sexual orientation is a protected class in there, and you discriminated against us because of our sexual orientation, right? What did the parade say? Well, they said a couple of things. The first thing they said was, no, it's not your orientation per se, it's the message that you're going to convey. If you were gay and marching for, mom and apple pie and puppy dogs, wouldn't matter to us. But your message is a message of gay pride, being gay is good, it should be celebrated, and it's the message we object to, not your identity. The court rejected that argument. They said, look, that's kind of the same thing. They just collapsed it. What's the next thing the parade said? Well, the parade lawyers read a bunch of Supreme Court cases and realized that there are limits on the power of government to tell someone to engage in speech or to facilitate somebody else's speech that they disagree with. So, they picked all these groups to be in their parade. Okay, all of them fit with our general overall rah rah America, Irish people go message, but the gay rights group just doesn't fit. And you government are trying to use the law to make us facilitate somebody else's speech. And there's a series of cases that have been decided before that time that said the government can't do that. So in a 9-0 vote in 1995, the Supreme Court ruled for the parade organizers. So it wasn't a religion coming. Religion was under there in the surface somewhere, but it was more of a free speech case than anything else. What came next? New Jersey. Places of public accommodations, just like Massachusetts, right? They had a law that forbid sexual orientation discrimination in places of public accommodation. There was a man named James Dale who had been a Boy Scout growing up. He was old enough to move into a leadership position in the Boy Scouts. Turns out that he was gay. He was, in fact, a gay activist who had been in the newspaper supporting gay rights. And at that time, the Boy Scouts had a policy that said, it's interesting, their policy didn't talk about homosexuality per se. It had a policy that said our leaders must be, quote, morally straight, was part of it. And I don't think they meant straight, like gay straight, but that was what they pointed to say, no, we're not going to allow you to be a scoutmaster because it doesn't fit. And so what did he do? Good American, got a lawyer, filed a lawsuit. And he goes into court, Mr. Dale, and says, look, the Boy Scouts are a public accommodation, which is weird, but the court agreed with that. I think hotels, restaurants, but anyway, so the Boy Scouts are a place of public accommodation. You've excluded me from it because of my gay identity. And that violates this law, this New Jersey law against sexual orientation discrimination. Case goes up to the Supreme Court again. What do the Boy Scouts say, by the way? First of all, they couldn't really argue that it wasn't about his identity, although they did say, look, this person is an activist and we're concerned he's going to communicate messages of approval of homosexual behavior to the kids, and we don't want that. The Boy Scouts, by the way, have changed their position on this issue. You probably know that. But at the time, they were saying, look, we're trying to convey a particular moral message to our scouts, and just his presence and the likelihood that he's going to talk about his sexuality and stuff like that makes him not a good fit. They didn't try to argue their way really around like whether they were discriminating against him based on his identity, but their argument was, look, we're trying to convey a message, including a message about homosexuality. We think it's wrong, and it'd be utterly inconsistent to have a gay scoutmaster. It would conflict with our message. It would make it harder for us to communicate our message. And the Supreme Court agreed with this. There's a line of cases that say a bunch of people can get together to communicate a message, and they can exclude someone who doesn't agree with that message, right? So they said, look, this person, their presence would undermine the Scouts' message at that point in time about homosexuality, so they won their case 5-4. Interesting. 5-4. Now, you can argue that the facts were different, the arguments were different, the composition of the court was different. My own view is that the growing level of acceptance of LGBT things played a role in moving that vote from 9-0 in 1995 to 5-4 in 2000. So again, we're seeing conflict. Again, this isn't really religion, right? The Boy Scouts are a little bit religious, but the religious stuff is coming. And I was involved in some of the earliest cases. So harken back to Harvard and Yale at the beginning. I was there in my capacity as an employer, or on behalf of my employer. That organization that I work for, Christian Legal Society, in addition to doing advocacy, also was a membership organization. And we had a law student function, a law student ministry, a campus ministry. And we had student groups at lots of law schools, most law schools around the country. And these law schools, unsurprisingly, had non-discrimination rules for their student groups. So if you're a student group that wants to be recognized, you want to get money, you want access to meeting space, you want to use, back in those days, no internet, the bulletin board to advertise your meetings, whatever, you have to comply with our rules. And one of those rules was the non-discrimination rule. And so CLS would show up. Okay, we would like to be a recognized student group. And oh, by the way, we let everyone come to our meetings. We want people who aren't Christians to come to our meetings because, again, one of their purposes was evangelistic. So they weren't at the door turning away people who weren't Christian or gay or something like that. But when it came to the leadership of the group, they did want those folks to be Christians, and not just in kind of checking boxes on a statement of faith, but in actual how they lived their lives. And there are lots of conduct standards. Some of them are about sexuality. And the law schools, as you probably guessed by now, said, no, this is discrimination. And our response was, well, no, it's not really. First of all, we're not discriminating against people because of their orientation per se. It's about behavior, a distinction between behavior and inclination. They rejected that. We made the argument that, the law, allows this, by the way. Every law that's out there at this point in time has exemptions for religious order. Why can't you do so also? And their response essentially is, well, we're better and more just and more progressive or whatever. And so they denied our request for recognition. So, being good Americans, they got a lawyer and filed lawsuits. And I was the lawyer representing a lot of these CLS chapters. And we were prevailing. We won a number of these cases. We represented other groups too, like there was a Christian fraternity, Beta Upsilon Chi, and some other student groups. And we were arguing, look, you're conditioning the receipt of a benefit upon giving up our constitutional rights. We have a constitutional right to decide who our leaders are going to be, and you're saying you have to give that up if you want to have access to meeting space or funding. And we were winning. We were winning in the 7th Circuit and the 11th Circuit and all these circuits. So then we had the bright idea to file a lawsuit in San Francisco against Hastings Law School in the 9th Circuit, which is one of the most notoriously liberal circuits out there. Well, it wasn't entirely a dumb idea. We had hoped that the Supreme Court would take this issue up. And why does the Supreme Court take cases? Mostly because you got Court A saying one thing in one part of the country and Court B saying something entirely different in another part of the country. And so the court takes cases to fix those conflicts among the courts. So the court takes the case, and we're like, great, we're going to resolve this. And then we lose 5-4. 5-4. Very disheartening loss. The most shocking thing about it was Anthony Kennedy, who was the 5th vote with the 4 liberals on the court at that time, wrote a concurrence. And he basically said that we're terrible people, that a statement of faith requirement is akin to a McCarthy-era loyalty oath. So a statement of faith, which is a common device, right, in churches and in religious organizations, he was like, the day and age, we're long past this idea or this kind of phenomenon where you're requiring people to sign a loyalty oath, a very pejorative way of characterizing what we and what a lot of religious organizations do. So that was kind of disheartening. Okay. So what happens next? Marriage. So LGBT organizations were suing states, saying your law that says marriage is one man, one woman, it's unconstitutional. It violates our right to equal protection of the laws. You must recognize same-sex marriage, right? And state courts started saying, we agree with you, right? So now you have a lot of gay couples getting married. And gay couples, just like straight couples, they want a venue, they want a videographer, they want a cake artist, they want a florist. You can see where this is heading, right? So a lot of gay couples were now newly in this world, the market as it were, for wedding services. And were and are Christian wedding vendors who do these services that I've listed, who for religious reasons don't want to help facilitate a same-sex wedding ceremony. So Elaine Huguenin, a photographer in New Mexico, respectfully declined and was sued and lost. Free speech rights and free exercise rights were rejected. You had the two most famous cases that ADF has handled are Baronelle Stutzman, the florist, and Jack Phillips, the cake baker, the cake artist in Colorado. And I think both the cases, the facts are kind of interesting because they illustrate what's really going on here. I think our friends on the other side would like to have people believe that Jack Phillips is just a bigot and that he turns away gay people at the door, which is false. They want to create the same impression about Baronelle Stutzman, the florist, who couldn't do a same-sex wedding. The customer who requested her to do the flowers for his wedding to his partner had been a customer for 9 years, and they were friends. They were friends. She had provided flowers to him for almost a decade. And when he came in and asked, it was a hard conversation, but she said, look, Rob, I'm sorry I can't do this because of my relationship with Jesus. And he was fine with it. He was okay with it. But apparently his partner wasn't, and somehow it got on social media, and the Washington State Attorney General saw this, and off to the races we go. And then, probably a dozen years of litigation. And she recently settled her case. It did not go well for her in the courts. She had religious liberty, free speech defenses, and they were rejected by courts. And recently she settled the case. It was her time to pass the baton on to others who would defend free speech and religious liberty. And so she retired from her business. The win for her was not having her personal savings, her house, and her business taken away from her, which is what the state and the other plaintiffs were trying to do. Elaine Huguenin, the photographer, she's out of business. Jack Phillips in Colorado is enduring case after case after case, even though he won his case. He won his case in the Supreme Court on relatively narrow grounds. So the rise of marriage, the recognition of marriage, the eventual federal mandate from the Supreme Court that all states recognize same-sex marriage has just accelerated this. The non-discrimination phenomenon is spreading into other contexts. Schools. So a lot of schools have school choice programs. A lot of states, rather, have school choice programs. A lot of schools that participate in them are religious schools. A lot of these religious schools are theologically conservative, and they have sexuality standards that reflect Orthodox Christian beliefs about the distinction between the sexes and marriage and sexual morality. And the states are telling them, you can't participate in the voucher program. So these poor families who are trying to escape failing schools are being told they can't go to a school that shares their faith and their beliefs. We recently litigated a case against the state of Maryland. We represented Bethel Ministries. It was a school, had a lot of kids in the voucher program, poor, underprivileged folks coming to this school because the state was helping them afford it. And then the state turned around and said, you know what, you can't go there anymore because of what this church believes and how it implements its beliefs. And the state also said, oh, by the way, the $103,000 that we gave you the last few years, give it back. Yeah, so we litigated that case. We had no choice, right? They didn't have that money. I mean, what small church has $103,000 lying around? So we litigated the case and we prevailed. And to make it even better, we won $200,000 in attorney's fees. So instead of us paying them $100K, they paid us $200. Well, so that was nice. That was good. But the Maryland legislature, as we speak, is finalizing new legislation that will be like sort of round two, and they're trying to work their way around what the court said. Adoption and foster agencies. In Philadelphia, they had been working with Catholic Charities for a century to help place children with adoptive and foster families. Catholic Charities, consistent with Catholic religious beliefs, would only place children with opposite-sex couples. Every other agency in the city was willing to place children with same-sex couples, so there wasn't really an issue of an inability of gay couples to participate in the system. As a matter of fact, Catholic Charities had never turned someone away. It had never happened, right? That a gay couple had come to them and asked to help, work together to adopt a child. But the Philadelphia nonetheless said, you're out. We know you've been doing this for a century. We know that you work with the hard-to-place kids, the older ones, the siblings that need to stay together. We don't care. You're out. So our friends at the Becket Fund litigated that case, took it all the way to the Supreme Court, and they prevailed in a case called Fulton. I think it was a year before last. But on somewhat narrow grounds, right? They really haven't resolved this. Finally, there's a case, another creative professional, not a wedding vendor, 303 Creative, Lori Smith. She's an ADF client. She's a custom website designer. And Colorado is telling her, you have to create websites that are inconsistent with your beliefs. You have to use your gifts to create speech that you don't agree with. Well, this sounds a lot like these cases where the government's telling people to say stuff, and the court has said no. So we're hoping to get a more significant victory in that case. Okay, 2 more things before we do questions and discussion. What's coming? What's on the horizon? There's a bill pending in Congress called the Equality Act. How many have heard of the Equality Act? A fair number. Yeah, it's a pretty significant effort to tip the balance, as it were. It would change a lot of things. First of all, it would probably make institutions like this one a place of public accommodation, and then subject it to a sexual orientation, gender identity, non-discrimination rule, which means admission standards, student conduct standards. You can't continue to maintain them. You can't give up something and keep your rules. It's the law, right? It's one of these, not a condition on a benefit, but a law that applies because you're in the United States. It would also condition the receipt of federal money on compliance with the sexual orientation, gender identity, non-discrimination. And by the way, I think this is important. When you hear sexual orientation, gender identity, non-discrimination, you think exclusion. And exclusion is bad, and exclusion is often wrong. One of the problems is gender identity, non-discrimination rules have been interpreted to require a lot more than just don't exclude people. So those who support these rules would say a gender identity non-discrimination rule requires the use of preferred pronouns. It requires giving access to men who identify as women, giving them access to women's private spaces like locker rooms and such. It requires the inclusion of puberty blockers and cross-sex hormones and surgery, top surgery, bottom surgery in employee health plans. And in the athletics context, it requires allowing men like Leah Thomas, who identify as women, to participate in women's sports. So in a sense, this isn't just about religious liberty and LGBT interests. There's a whole other set of, and many of the affected parties are women and girls. Anyway, the Equality Act, it would add a gender identity and sexual orientation non-discrimination string to all federal money, which means almost every school, well, certainly every public school, most institutions of higher education, and some private institutions of K through 12 education would be subjected to a SOGI, sexual orientation, gender identity, non-discrimination rule. It also touches employment, housing, and a number of other areas. And just for good measure, it eliminates religious liberty protections. So the Equality Act imposes all these burdens on religious exercise and then says, hey, this wonderful statute that's on the books in the federal system called the Religious Freedom Restoration Act, you can't use it to defend yourself if you get sued under the Equality Act. So it's quite a thing, quite a piece of legislation. I have to point out that there was a change in around 2014, the LGBT advocacy organizations used to accept religious exemptions, and then in 2014 they essentially decided they're not going to anymore. There was a bill pending in Congress at that time about employment and had an exemption in it, and they supported it, and then they didn't. They withdrew their support from a pending bill. Why? Because it had a religious exemption in it. So really it's been kind of no space for compromise, really, since that time. There was an effort at compromise. Some Republicans introduced a bill called the Fairness for All Act in Congress, and the most vociferous opponents of it were leaders of the Democratic Party in the House and Human Rights Campaign, Lambda Legal, National Women's Law Center. They were like, this is a terrible bill because it has exemptions in it. So I'm not sure there's much hope for some kind of compromise on this issue. What do I predict? And I'll stop with this. I don't think there's going to be some big event that shifts everything one way or the other. Like some Supreme Court case, one side wins, right? I don't think it's going to be that. Or the Equality Act passes and other side wins. I just don't think it's going to be that way. I think it's going to be more of what we've seen for the last 20 plus years, which is you have a state or a locality, maybe the federal government adopts a rule, and then there's pushback, and then there's litigation, and the litigation kind of sets a precedent, but not a sort of, oh, we don't have to litigate anything anymore, it's all decided. So I think it's going to be this lengthy battle, and I don't think anybody's excited about that. I'm not sure I am, but I think that's just the way it's going to be. So for those of us who do believe in the traditional Christian sexual ethic and who do support religious liberty, we're in for some years of continuing to struggle with this question. So I hope I've shed some light, not too much heat, but more light than heat on contentious issue, a sensitive issue, a complicated issue, an issue that means a lot for a lot of people. And I think we're ready for a time of discussion, questions, critiques, rotten fruit, whatever works.
Maybe not rotten fruit.
Okay,
regular
good.
fruit's fine.
Thanks,
But not
good.
rotten. So if you do have some questions or have some thoughts, pushback, comments, please go ahead and raise your hands. Julia's going to bring the microphone around to folks. I'm going to use my prerogative as the assistant director to ask the first question. Hopefully that's okay. We've obviously had a great deal of contentious debates throughout American history in a variety of contexts. Some of them led to a civil war. I'm curious if, in your mind, this particular point of tension is inherently different, and if so, is this contention, like you said, just kind of continuing for the next, several years, decades? Is this a sustainable process to have?
I'm honestly not sure. I'm not trying to dodge your question, but I'm honestly not sure. I do think it's sustainable for jurisdiction A to pass a law and someone to challenge the application of it, and we do that for years and years. I think that's sustainable. I think there are sort of non-legal factors that play into this, like cultural factors. I think everyone would probably recognize this, that the percentage of Americans that hold to the traditional sexual ethic is smaller than it used to be. And that has consequences, right? It has political consequences and potentially even legal consequences when certain points of view become kind of outside the Overton window or beyond kind of polite discussion. So I don't know how long this is going to go on. I am intrigued to see how the gender identity issue plays out. I think that one is more liable to something that resembles a resolution because a lot of the things that are happening, there's scientific answers in a sense. There a lot of the medical organizations hold that it's appropriate to do puberty blockers and cross-sex hormones and surgeries, but there are studies. Scientists can study whether this works or whether it makes things worse, or it's hard to know. And there are countries in Europe that were kind of ahead of us, so to speak, on the timeline. England and some of the Scandinavian countries who dialed back on this. And it's very difficult now to get medicalized transition of a minor in some of these countries because the science wasn't proving out, right? If you do this, the person's distress will go away. Their depression will go away, their anxiety will go away. And we're starting to learn more and more about the population, particularly of teenage girls that present with a gender confusion. And there's a lot of comorbidities like autism and anxiety and depression. And the number of girls particularly who've identified as transgender, the percent is like in the thousands. It's how much it's gone up. It used to be a phenomenon of younger boys, and it was almost non-existent. And now you have, some have called it rapid onset gender dysphoria. There was a professor at Brown who did a study. It's almost like contagious. There might be a group of friends. If one starts identifying as transgender, then there's 2, and then there's 5. And these are questions worth studying. And I think there will be answers. And they have to be studied, right? Because think about the consequences. Sex, there are different words to describe this. Sex reassignment, gender affirmation. There's lots of different words to describe the surgery that's done. But we know this, it sterilizes. So, if you're a mom and your daughter wants to get this surgery, you have to realize you might not be a grandparent. And that's what's happening. I don't think a lot of parents are being fully informed about this stuff. So, and the sports thing. I think the recent phenomenon of Leah Thomas winning all of these Ivy League championships and NCAA championships, a lot of people who don't have any religious bone in their body and don't care about this from a religious perspective are saying, this is just not fair. So I do think that aspect of it is more liable to something resembling a resolution. So anyway, that's my best effort at an answer. I hope that's modestly satisfying. Who's next? In the front?
You discussed the paper about Brown University, and I think it's interesting. Literally just yesterday, I listened to an episode on the Ben Shapiro show where he had Neil deGrasse Tyson on, and that's one of the points that they discussed, how Brown released that article or paper on rapid onset gender dysphoria, and then they pulled it, and then they re-released it again. And hearing Ben Shapiro and Neil deGrasse Tyson's takes on it were really interesting, and I wanted to also suggest that. He's an astrophysicist and very well studied on things such as this, so I would recommend that people also listen to that if they want more information on different perspectives and what the scientific community has to say about that.
No, that's a good point. Her study has not been universally accepted as valid. Some people have questioned it, and I think that's how science works. So thank you for adding that.
So outside of the religious context, is there legal precedent for people to file lawsuits when they feel like organizations haven't discriminated towards sex like they should? So I'm thinking about the school situation in Virginia where a man's daughter was raped in a woman's bathroom because a boy who identified as transgender was in the women's restroom. So would there be legal precedent outside of the religious context for the father to file a suit against the school?
Yeah. So did everyone hear the question? Okay. I'm not an expert. I don't purport to be an expert in this area of the law. But I will venture out a little bit to give you my sense of the way things probably are. The law recognizes that all of us owe duties to other people, and we can violate those duties and suffer consequences for it legally. And none of this is written down in a statute, but like a tort. Like if you run someone over with your car, you can get in trouble with the police, but you also can get sued, right? And they don't invoke some kind of statute, it's just common law. And so there's a tort. So I would imagine, there could be, and again, this is not my area, I don't know, a valid cause of action for a parent who says, look, you were responsible, you had a duty to my child to protect them, and you didn't. And then it goes to trial, and so or there might be a statute that pertains specifically to the duties that public school officials have with respect to their students. Again, I don't know. So I don't want to speak too much out of turn, but I think there are probably legal remedies, and it may be the case that the dad in that circumstance in Loudoun County is communicating with lawyers as we speak. I'm sorry, I don't know, but I think that's a viable option. It strikes me as one.
All right, so I have two kind of questions. One of them is about the Trump administration's Title IX actions in 2017, removing transgender as a status in Title IX, and I was just curious if you had any play in that, considering your history with those sorts of things. And also, I don't know, I've just been kind of like thinking like, what exactly makes race, and it's something that's you're not allowed to discriminate.
Yeah.
Why exactly is that? It's because it's not something you can change. It's just something you're innately born with, and sort of can't really change that. Well, study after study has recently, like as recent as 2002, but been showing that, it seems that there's no real successful way to change orientation or gender identity to just with the failure of conversion therapy. I mean, there's one paper in the journal, where is it? Professional Psychology Research and Practice, that shows a hilariously low 13% success rate within their studies in 2002. And even then, half the people, after they did their 2-year checkup, that did say that it worked, refused to answer and talk with them anymore. So it just seems like, to me personally, that seems like sexual orientation and gender identity seem to have this sort of intransibility to them. And whether or not that's something that's formed in childhood or nature, definitely seems to be both components, but it just seems like something that doesn't change.
Yeah, excellent.
So I'm curious how you view that,
Yeah.
and whether that could be applied to, say, the same sort of situation with race, since it's inchangeable,
Right.
shouldn't be discriminated
Yeah.
against in any context.
Excellent questions. Excellent questions. Let me answer the first one first. So Title IX is Title IX. It's just Roman numerals, so we say Title IX. But it looks like that. It looks like ticks, doesn't it? Anyway, Title IX. So Title IX bans sex discrimination. What else? It doesn't say sexual orientation. It doesn't say gender identity. There have been efforts by folks to amend the federal statutes, right, that forbid discrimination, to add sexual orientation, to add gender identity. All those efforts have failed. In 2013, the Obama administration's Department of Education started interpreting, just sort of by fiat, the ban on sex discrimination in Title IX to reach gender identity discrimination. So essentially they said, we're tired of waiting for Congress to do this thing we want them to do, and so we're just going to do it, right? So they did it. Now, in response to that, a lot of religious institutions took advantage of a process that the Department of Education has, whereby a school can confirm or get assurance of its possession of the Title IX religious exemption. So, and I helped a lot of schools do this. You write a letter from the president that says, look, you guys are interpreting Title IX this way for religious reasons. We're going to maintain our conduct standards. We're not going to allow men who identify as women in the women's dormitories or on the women's sports teams. We're not going to use a preferred pronoun, whatever it is. And really, there's not a lot of discretion on the other end. The department basically has to say, okay, and then they send a letter back, and now you have this letter. So when the Trump administration sort of did reversed course, as it were, I think they were doing the right thing as a matter of interpretation of the statute, and I think they were doing the right thing as a matter of who gets to make these decisions, right? I think part of their rationale was, hey, they usurped Congress's authority. Congress is the one that writes the laws and rewrites the laws. So anyway, that's what I'll say about the first one. That's an easier question. Yeah, your second question, I think it started with why race is different, and I think I heard you making the argument that, well, if race is different because it's unchangeable, sexual orientation, gender identity aren't changeable also, so that's not the basis of the distinction. I don't think that's why race is treated differently. I think it's because the history of race in the United States is so unique and awful. I mean, you have slavery, you have Jim Crow, and I think the idea is like, well, we can't, we can't, right? We can't have exceptions from race discrimination. So I don't think it's the immutability that really drives those of us who would draw a distinction, right, between race and other things. I'm not a scientist or a social scientist. I've read some papers as you have. I think you're right that it's very difficult to change sexual orientation, to change attractions, particularly with males. I would probably beg to differ on gender identity. There are studies that show that if you just allow a child, it's called watchful waiting, to go through puberty, that around 89, 90, 91% of the children, they call this desist. They desist from their gender confusion, and their self-perception aligns with their bodily reality. So that's gender identity changing even without any interventions. The other thing is, like, it's weird to talk about gender identity being fixed, because that's sort of incoherent, because the whole premise of gender identity is that it's fluid and changeable. And then to say, well, it's not changeable and therefore it's like race, I just don't think that argument works. But I think the better argument is, like, there are plenty of cases, right, where people were confused about their gender and then they weren't. And a lot of times it's just because of the passage of time and puberty happening. So for what that's worth, I hope that's helpful.
And may I push on your earlier notions about sort of the history between race and the history in the United States? And I would kind of like to be curious, because there is a large history of oppression towards LGBT, or maybe we should limit, because your biggest argument to LGBT, but so obviously you have things like police riots back in the 60s and 50s and beforehand. And you've had like various things like cities, various police brutality during marches and stuff like that. And albeit it's probably a lot less talked about because those sorts of people like to mythologize a lot of the events. But I don't know, it just feels like to me that it seems there's also a large history there of active oppression and heinous acts against the community.
Yeah, no, I'm not, to distinguish the two is not to say that there's no history of that. Of course there is. I mean, it's undeniable, right? And this is hard, you can't answer this question almost mathematically, like, how much worse was the experience of African Americans? I mean, it's tough. But I would argue that, and I think most people would agree with this, that the African American experience is worse. But how much worse, and how much does that matter? And these are questions that are hard to resolve in a setting like this. But I understand your point. You could say the same thing about some of the other protected classifications as well, like national origin, right, and sex. Women denied the franchise, and other forms of legally required discrimination that have existed. So, there's a reason why these non-discrimination laws exist. The question of whether you should elevate sexual orientation, gender identity to the level of race, where there's no exceptions, is a different one. And I come down with, I think they are distinguishable historically, and there ought to be different treatment of the two classifications in non-discrimination laws. So, but that's a hard question. It's a tough one. It's not susceptible to, like, let's plug in, do a formula with a calculator and we'll get the right answer. It's tough. Who's next?
Yes. My question is also twofold. First, do most institutions that you work with, like JBU, have sexual conduct that is inclusive of all sexual sins, such as sex outside of marriage? And do those conducts seem to bother other organizations as much as homosexuality does?
So that first question is yes. I've never encountered, I'm not saying they don't exist, because I'm not omniscient, but every school or religious organization that has a policy about sexuality doesn't limit it to homosexual behavior or transgenderism. It has the old-fashioned words like fornication. They don't usually say that anymore, but premarital intercourse, extramarital intercourse, it's opposite sex. And what I found is that with some exceptions, they're pretty consistently enforced. There's always, anytime you have a policy, there raises a question, is it being forced consistently? Is it being forced fairly? And again, I don't have comprehensive knowledge, but my sense is that they are. Your second part of your question was, do people like, Harvard and Yale, do they care that CLS says adultery is frowned on? And the answer is no, they don't care, right? Because who's the protected class there? It doesn't say adulterers, as a class. So yeah, so we care about all of these things, and they care about some of them, and thus the tension. So good question, yeah.
Okay, so if, obviously church and state, they're, historically they're separate. But there, a lot of where this is coming from is from a Christian perspective. Where's the line between if my religion says, well, I think, LGBTQ community is great, should the church really even have a say in that conversation? Because, personal individual freedom, there's two people could disagree. What makes, Christianity right from a secular sense?
I'm sure Professor Bennett has thoughts about this question. But no, this is a great question. So if I can just recharacterize your question, tell me if this is not fair. There's long been a debate about the role of religious arguments on public policy questions, and whether that's legitimate or not. It comes up a lot in the abortion context, right? Because a lot of people their pro-life position is motivated by their religious views, right, about life. And historically, America has said that's okay, right? That's not illegitimate to bring your religious beliefs into your role as, say, a legislator who's voting on a bill. And I think it's entirely legitimate for a legislator to vote on their views of sexual morality in marriage. And there are obviously people on both sides of it, and there are people on both sides who are motivated by their religious convictions. So I think it would be very difficult to police it too if you sort of had a no religious motivations rule. How would you even know, and what counts as religion? And a lot of times people have multiple. I have issues with gender identity stuff and medicalizing transition of children for religious reasons, but kind of for, wow, this is a really bad thing. It's not helping and it's hurting. It's kind of a secular almost kind of reason. So now there's a separate question, which is how persuasive is it to go to someone who doesn't believe in the Bible and say, hey, look, the Bible says, right? That doesn't work. So if you're coming at an issue from a religious perspective, it's not necessarily an appropriate strategy to use religious arguments to people who don't share the same presuppositions that you do. So anyway, I think, there's a prudential question, and then there's like a principle question. And in my view, it's totally appropriate and it's consistent with American history to bring religious arguments into these
So would you
issues.
say, like, if somebody was not Christian and of a different religion, they should be able to live fully, because, for example, in schools, there's a lot of the school schedule is often built around Christmas, a Christian, holiday.
Yeah.
So what about, the other religions that also doesn't affect, where does individual freedom come into that? And that, because that would tie into LGBTQ issues in schools and individual freedom within that.
Yeah, no, I mean, that's a difficult issue because it's funny that you say this because I grew up in a heavily Jewish area, and, we always got Yom Kippur and Rosh Hashanah off from school, and I'm like, Christian kid, like, this is great. I don't have to go to synagogue, and I get the day off. So, but, it was because the decision by the schools reflected the character of the community. But you can see why. People would say, well, look, I'm Sikh, and I have this holiday, and I'm Muslim, and I have this holiday. And you get into this business of like, well, what percentage? I mean, it's really hard. And that's why I kind of think that a lot of these decisions are best handled at a local level rather than a one size fits all solution. But no, I think you put your finger on just a problem that arises out of having a pluralistic society. And I don't think we would give that up to get rid of these problems. So I think it's just something we have to live with and work through, hopefully in a rational manner with our neighbors.
and I'll interject something really quickly.
Yes,
I'm so
go,
sorry.
Professor Bennett.
But one of the most famous free exercise of religion cases of the 20th century involved a Seventh-day Adventist who said, I shouldn't be required to work on Saturdays because of my religious faith. And the state of South Carolina said, no, you should be required to work, otherwise you don't get unemployment insurance. And the court said in that case that she should, be given that exception. So I think this pluralism conversation is really, really important as we become less institutionally religious moving forward.
Yeah.
So I love that. Great stuff. Sorry, back to Caitlin.
You made us both happy.
Back to
with your
Caitlin.
question.
Okay, so as a lawyer, I'm sure you're going to love this. I'm going to ask about changing the facts of a case, okay? So if it's in the Catholic situation with the adoption agency, right? You said that there were other agencies that they could go to.
Yeah.
So my question is asking if there weren't other agencies that a non-heterosexual couple could seek out an adoption, does that change the matter? Focusing on what is a right, what is public accommodation. There is my question.
Yeah. So it's funny you said lawyers, you hate to change it. This is what happens at oral argument in front of judges. They take your case and they change two facts. And they say, well now, because they're trying to explore the boundaries of your principles, right? And they're trying to find out the ramifications of your principles. So that's like bread and butter of standing up in front of an appellate judge, and they change the facts. And so I'll say this. A lot of these cases come down to balancing interests, right? It's very rare where, okay, this side always wins when you have a conflict like this. And for example, that religious freedom statute that I was talking about, it sets up a test for balancing. And the first question on the test is the judge asks the religious person, so explain to me why your religious exercise is being interfered with. What's so bad about complying with this law? How does it really hurt you? And then they'll say something like, well, this makes it a lot harder for me to exercise my faith, or the government's forcing me to do something that violates my convictions. I'm a doctor. I don't want to be in the death chamber injecting the prisoner with, doing capital punishment. I don't want to do that. That's against my religion. So if the person is able to satisfy to the judge's satisfaction that what the government or the other party is trying to do to them burdens their religion enough, then the court will turn to the other side, turn to the government probably, and say, what are you trying to get at here? What's your goal? What's your objective? What's your public policy objective? Question one. Question two, is there some other way you can accomplish that without hurting this guy? So those in the text of the statute, is there a compelling state interest? Right? A compelling state interest. And you can see how that could be in the eye of the beholder, right? So the outcome of these cases turns on substantiality, eye of the beholder, right? Compellingness. What's a compelling interest? You could make plausible arguments from precedent that eradicating sexual orientation discrimination is a compelling interest. You can make a plausible argument that it's not, right? Those are both plausible arguments. So this is where judges and their approaches become really important. So that changes the balance. You're changing the facts, right? Now you have, a same-sex couple that has no option, right, to adopt. That changes how you think about the government's interest, right? Because the government has this rule so that same-sex couples are able to participate in this whole process. And so, it changes the balancing. And whether it changes the outcome, I don't know. In that case, you can't know, right? Because they reached their conclusion because they balanced this and they balanced this, and they didn't tell us, if you change factor X, we decide the different way. So it's a predictive matter. I'm not sure how that would turn out. Now, as a practical matter, this isn't how it works, right? Jack Phillips, there was a lot of other bakers in Denver who were willing to bake the cake, and they all showed up after Jack didn't. There were a lot of other florists in suburban Seattle who were willing to do the flower arrangements for the same-sex weddings. So I'm not saying this is not possible, but at least in the scenario of the wedding vendors, it does not seem to be a real thing where they're the only game in town. So if that's helpful. Yes, follow up.
So I understand, like, it's probably not practical, and the proportionality of, like, heterosexual couples to non-heterosexual couples differs a lot. But being from, like, smaller town Midwest areas, that'll be different than the Seattle, than the Denver. And so coming from, like, my perspective, if I were seeking out services that I were not heterosexual, I would have a really hard time finding services that weren't faith-based specifically. And so I think that my concern hinges on, like, does the government then, with the balancing act, can the government say your religious belief is less compelling because you're the only service provider?
Well, that's certainly the argument that gets made, but I think you raised an interesting question, like the reality of a small town, in a rural area. What obligation does the government have to essentially deal with the negative ramifications of that reality, okay? And do they do it at the expense of someone else? Now, there's someone else on the side of this equation, and they're literally saying that this will damage my relationship with God, that I will violate God's law, that I will violate my conscience, which is long held to be sacred in the United States and other places. It's hard to weigh that, right? Because it's like it's in here, but that's significant. We've always said that's significant. That's why we don't make a doctor go into the death chamber. That's why we don't make doctors perform abortions. There's all sorts. That's why conscientious objectors don't have to go to Vietnam and shoot people. I mean, so there, it's, I would make a plea to adequately weight that interest on the other side. I'm not denying that there are an interest on both sides, and they can feel worse, right, because of the different setting. I'm just not sure it's the government's job to come in and coerce someone to do something that violates their conscience.
1 second, sorry.
Oh.
Historically, there have been religious organizations in the United States that have held belief systems that believed interracial marriage is wrong. If these belief systems had persisted in these communities today, and someone wanted to discriminate on the basis of race in business services, such as catering for an interracial marriage, would that be protected by the law? I don't think so. So why does that change when it comes to marriage between two people of the same gender?
No, this goes back to the question. Well, so the answer to your question is, would the law allow that? Is no, right? There were some cases in the 60s that involved this, where people had religious rationales for race discrimination. And the courts didn't dismiss their religious beliefs. They just said the interest in eradicating race discrimination overrides it. So we're going back to this question of, is race different, right? And I've already said, I think it is different, and I think eradicating race discrimination can override religious interests in a way that other things don't. It's been the belief of the Abrahamic faiths for 2,000 plus years that marriage is between a man and a woman. This is not some lightly arrived at position that they hold. So I think it's entitled to more respect than really very difficult to justify hermeneutic about interracial marriage and all that stuff. But just the history of the United States, not so much who's right about the Bible, it's more the history of the United States, I think, justifies treating race different than other protected classifications.
We have time for one more question.
Okay.
Is that okay? All right. I saw this hand first, so.
Hey, so if you're Joe the plumber, a lower middle class Orthodox Christian, and you feel like the world is starting to encroach on your way of life, on your religion, what means do you have to enact change? How do you protect the faith?
Yeah. Wow, that is a great question. I'm going to recommend a book. It's on your desk, this book, The Benedict Option by Rod Dreher. A lot of people don't like the title. A lot of people misinterpret what he recommends, but his point is that we need to focus on the church. I think there's this idea that the church is solid and everything outside it is not. That's not how it works. You know, there's a lot of the problems in our things that I would characterize as problems in our culture are very much in the church as well. And he makes a plea for discipleship, for catechism, for getting down to the basics. Don't let the culture catechize your children, do it yourself. I think what I like about what he says is that it's not a political solution. Yes, you can do political things. You can vote for people who are more likely to do Act X than Act Y, for sure. You can advocate for the adoption of legislation, stuff like that. But from a long-term perspective, I think it's important for people, whatever their views are, to take them seriously themselves, which is a problem, and to train up their children. I think that's the only way that there can be, kind of a permanent and lasting change. And whether that'll happen or not, I couldn't say. There's a lot of things in the currents of American culture that run contrary to sort of Christian ways of thinking about people, and Christian ways of thinking about the world, and Christian ways of thinking about eternity. So it's like a fish swimming against the stream. So it just requires all the more energy and all the more commitment, all the more dedication, all the more willingness to be unpopular. And that's a thing that it's hard for a lot of us. It's hard for me. It's hard for a lot of us. But great question. It's hard to answer that in a short. But anyway, read Benedict Option by Rod Dreher. I recommend it. He helps with that.
Rod Dreher, a 2017 guest at John Brown University. Interesting.
All right.
Interesting. So thank you all for being here tonight. These are important conversations. These are difficult conversations. They're contentious oftentimes, but I think these are essential conversations, especially in the years and decades to come as these tensions continue to bubble up and not go away. Yeah. So thank you all for being here. Thank you, Greg, for coming to campus tonight. We really appreciate your time.
Thank you.